Hello and welcome to the April edition of the Landlord Advocate. My name is Robert Chesson. I'm the managing partner here at the Landlord Law Firm. Here with you today to start our next three-part series in this series we're going to talk about the court process. We're going to talk about the court process before it actually gets to court. We're going to talk about getting through the court itself, and then ultimately we'll talk about what happens once you've got a judgment in your hands. And we're actually going to talk about this a little out of order, primarily because many of you are probably more interested in what actually happens once the court process starts, and so we're going to cover that one first. And then over the course of the next couple of landlord advocates, we're going to discuss the pre-court process and then the post-judgment process. So with that, let's kick it off. We're going to start this segment. Again, this is what it takes to actually get through the courthouse. And this segment is going to make reference to and deal specifically with, after a case has been filed in court, what happens next? How long does it take and what you can expect? So with that, once the case has been filed in court and the timeline kicks off, the timeline is kicked off by something we call a return date. It's just a mystery date that we get to select when we start the case. But once that date hits, then the clock starts ticking for the court process. That clock starts ticking specifically for the defendants, the tenants, in most instances, to file paperwork in the courthouse. That paperwork is legally termed an appearance and an answer. They are required to file them both. Sometimes they file one or the other. And not both of them. If they fail to meet their deadline for that filing, then the next step that your attorney can take is to seek a default judgment. That default is either for their failure to appear, file that paperwork, or to answer and file the necessary paperwork to keep the case moving. Sometimes those judgments are granted on the papers. Oftentimes what we see in the courthouses is they are handled by the clerk in a fashion where you file the paperwork and then ultimately, or you file the motion, your attorney files the motion, and the tenant files something in the interim, and ultimately you don't get that default judgment. But assume for purposes of the conversation now that you've got that default judgment and you've now won the case. It is now time to shift into obtaining the execution, the post-judgment documents that you need to move forward. That is the fastest way that a case that you've started in court can possibly be resolved, is you file it, you get a default judgment, and nothing happens thereafter. What's the next fastest way? Well, the next fastest way is that the tenants actually file the paperwork necessary, your attorney closes the pleadings promptly, and now it's time to get it scheduled in court. I can tell you as a practical matter, depending on what courthouse you're in, there are a couple of things that impact the schedule right away. The first is the number of cases the particular courthouse has to deal with. For example, up in Hartford, they get quite a number of cases more than you may get down in New London or over in Waterbury, for example. And so you will see in various courthouses the time frames for assigning cases to court will vary. Most of the time it's somewhere between a week or 2 weeks after the pleadings have been closed by your attorney. And then you can expect to be in court on that day. In some instances it's longer. In an occasional instance we've actually seen it a little faster than that, but most of the time you're looking a week to 2 weeks to actually be in the courthouse. What happens when you get there? Well, a couple things. In every courthouse, you will go through a mandatory mediation session. Many of you who've either been to court or at least talked to your attorney while they're in court know that they're meeting with the housing mediators when they get to the courthouse to try to see if there's a way to resolve the case, to settle it without the need for presenting evidence in front of a judge or going to a trial. And so the first experience in most instances of going to court will be the effort to mediate the case. There are some courthouses, although very few and far between, where if you are unable to mediate on that first visit, you'll actually get a trial in front of the judge that day. And in those courthouses where you may get a trial that day, you may run out of time or there may be more cases than they can actually try in one day. And so, although they would otherwise give you a trial that day, you might be rescheduled for another day. The most conservative approach is to expect that if you're unable to resolve the case on the first visit through mediation, through a settlement, that you will end up being scheduled for another day for trial. That is what most courthouses are doing these days, and that simply means you're going to be back the following week or perhaps 2 more weeks to actually present evidence and seek a judgment from the court. However, that is a very rare occasion. Certainly those of you who work with us understand that there are benefits to resolving cases on terms that you get to control versus leaving things up to the whims of a particular judge. The judges vary around the state on how quickly they make decisions. They vary on how aggressive they are with applying the law. They vary at how much leniency they might give a tenant who's facing an eviction. And so having some control over the outcome of the case, we suggest, is often better than having no control and leaving it up to whatever the judge might decide to do that day. That being said, if it is scheduled for a trial, you can expect to spend a few hours to a day presenting evidence to a judge in order to actually get your case heard. If that's the case, again, like I said, you may end up coming back on a future scheduled date to actually present that evidence to the court. Once you've got your judgment, whether it's by agreement, whether it's by default, or whether it's ultimately through a trial, then you shift into the post-judgment arena. And the only part of the post-judgment arena I'm going to cover today is what happens if you've settled the case on what we call that stipulated agreement. Right? The stipulated agreement is the court-approved settlement agreement that basically takes what you've negotiated, reduces it to writing, and then becomes an order of the court. It's a very, very valuable tool for you as a landlord because that agreement now reconfigures the legal relationship you have with your tenant. And if the tenant violates that agreement, it's not just a lease violation at this point. It's not just a failure to pay the rent, for example. It's now a violation of a court order. And the law allows you to return to court very quickly on what's called an affidavit of noncompliance and actually present to the court in a abbreviated fashion the concerns that you have with the tenant's compliance with that judgment and to seek redress, to get an order to have them removed, to change the terms of that agreement, or in some instances, it will be scheduled for a hearing and the court will actually determine that there hasn't in fact been a violation of that court order. The majority of the time they don't get scheduled or don't go to a formal hearing because oftentimes when you go back to court on those non-compliance issues, you're going to be able to negotiate a resolution to satisfy your needs, whether it be the tenant moving out voluntarily or you adjusting terms to meet whatever concerns you might have at that point. That whole process, how long does that take? Well, from the time the case starts, so that's when we file it in court and you actually get your judgment, you're probably looking at somewhere in the 4 to 6 week range. It depends on the parameters that we spoke about before, whether or not the tenant actually files the paperwork they're supposed to, how quickly the courts actually act on the default that you're requesting, what the timing is for the court schedule, for when they're actually scheduling trials, when they're scheduling cases to come to court. And so you're looking at roughly 4 to 6 weeks. We see an average of about 4 weeks for most of our cases. We're very aggressive in trying to get the pleadings closed so that you can get to the courthouse as fast as possible. Again, depending on when the courthouse is handling things and how they're scheduling stuff, it could be a little bit longer than that. So once that case starts in court, there's lots of variables that impact how long it could take, but ideally you should be getting that taken care of in a matter of weeks. Next month, we will come back to this series and we'll talk about the stuff, the things that you're going to be doing, the things that we will help you do in advance of filing that case in court. And then coming up in, what's it going to be, June, I have to count my months out. Coming up in June, we'll talk about what happens once you've got that judgment and you need to enforce it in a way that ultimately may require an eviction. Well, I hope that was helpful, and stick around. We will have another episode next month of this series, and we also have, if you will check out our links, some landlord news coming up on another episode here this month of The Landlord Advocate. Thanks for joining me. Again, I'm Robert Chesson with the Landlord Law Firm. We look forward to seeing you next month. Take care.